This is a box.
That's a good start.
This is the box where Jorge Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. Jorge Torres was zipped up in this box. Jorge Torres took his last
Is this cacciatore?
breaths in this box.
Suitcase.
The medical examiner explained to us
Yes.
that with each breath Jorge Torres took in, there was less oxygen in this box. Jorge Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case. This is what our duty is.
I just laugh every time they say duty.
And let's have a discussion regarding that law that we've just been read.
Yep.
here.
It was a loud an hour and a half for that.
First
Wasn't
section
That
of
pink
notes
cardigan.
we're going to come to is called Introduction to Homicide.
Oh, Lord.
But this being a legal document written by a bunch of lawyers, you've seen for the last 2 weeks.
I don't want to see any more of.
Pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all of
Was
them.
waiting for
And if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide, we come to the first section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because Jorge Torres was zipped up in that suitcase. He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident, and in misfortune, doing any lawful act by lawful means, usual, ordinary caution, and without any unlawful intent. Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when George Torres was in here,
Nothing worse, is there, when you can't reach it?
he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could
My nose
feel
rings
her grievances.
loose.
Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution.
Oh, look at those manicured nails.
In this circumstance.
Mm-hmm.
Second,
They're nearly as poor as mine.
occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation.
Mm.
George Torres couldn't provoke anything from his circumstance. George Torres was confined to this box. Next.
His suit's all
The
bunchy.
killing is committed by accident and misfortune resulting from a sudden combat. A dangerous weapon is not used. The killing is not done in a cruel and unusual manner. This fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for George Torres. And it fails on the 2nd count because George Torres was killed in a cruel and unusual manner. Next, we turn to our main charge, 2nd degree murder. And the law informs us that to prove the crime of 2nd degree murder, the state must prove the following 3 elements beyond a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of 2nd degree murder to be, for the defendant to be.
I'm sorry. I pay a shit ton of money for high def 1080p, and that is the picture that you give me. Unfortunately, the court feeds only probably only go up to 480, 720 at the max. They don't stream any higher than that. I don't know why I bother.
Be found guilty in this case. We've been
I can't even
hearing
read that.
all kinds of facts for almost 2 weeks now of trial. But these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven 2nd degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, George Torres is dead, well, we have stipulation, amongst other things, that agrees to that. As to the second fact, the death was caused by Sarah Boone. Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. zipped him up in the suitcase, and she refused to zip him out. 3, there was an unlawful killing of Jorge Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is, and also what an act is. And it's going to tell us that an act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature the act itself displays an indifference to human life. Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you. ING 1062, states 17. Mr. J, may you publish states 17?
Sarah. For everything you've done to me. Sarah. For everything you've done to me.
That's loud.
Sarah. Fuck
Yeah.
you. Sarah. Fuck you. Sarah. Stupid. Sarah. That's my name. Don't wear it out. Sarah. I can't fucking breathe, babe. Seriously. Yeah, that's when.
Isn't a scintilla like a titsy tiny? Isn't it? Scintilla? I'll Google it.
You do me, choke me, Sarah.
They paused that, didn't they? It's not me. You know, good. Scintilla. I shall Google it. What the? What happened there? I wonder if that was one of George's family members that had to leave the courtroom, perhaps. Hmm. She's passing notes in class. You'll get detention. What the hell's going on?
You may continue.
Well, we're just going to have to get on Twitter and wait for Jules to update us.
Sarah. Sarah, I can't breathe. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real or ransom? Now you want to give video for it extra. Because I got it. Sarah. Real or ransom? Sarah, I can't breathe, babe. Oh, that's what I feel like when you drink on me. Sarah, fuck you. I can't breathe, Sarah. Yeah. You should probably shut the fuck up. Sarah.
Ladies and gentlemen, that exhibit removes any scintilla of doubt.
Scintilla.
Of depravity. Of
I will
defendant's
look it up.
actions. But we know from the evidence that this was not the first time she had considered killing Jorge Torres. We know from the evidence that on January 13th, 2020, approximately 1 month prior to Jorge Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. Bless you and all of you too. I'll get rid of him, then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death,
A scintilla, a tiny trace or spark of a specified quality or feeling. A scintilla of doubt. And we all spelt it wrong. It's SCINTILLA. There you go.
is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case. So turning our attention towards voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered. And that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's
Read on. That's not all of it.
evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First, we come to the justifiable use of deadly force. It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force.
He's just reading out the jury instructions.
Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty,
This is what the state comes up with for their closing. They read the jury instructions and a box. Really?
the state must prove beyond a reasonable doubt Sarah Boone was not justified in using deadly
I
force.
just heard the judge read this.
The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise.
In a few moments.
He is going to show you
How long's it been going for?
this.
$45 minutes.
And
And
this.
so uses the jury instructions pre-prepared and the defense's demonstrative aids and a box.
This.
Good closing, sir. Good closing. Good job. You only had 5 years to prepare for this, but whatever.
And he's going to talk. And this as well.
No wonder there was no objection to them being
About
used.
the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods.
Mm-hmm. This is ridiculous.
He's going to talk to you about black eyes.
Yeah. He can't even walk fast. It's like,
He's going to talk to you about what an awful, awful boyfriend Jorge Torres was.
maybe he was. Doesn't mean he deserved to die.
And ladies and gentlemen,
Doesn't mean she didn't deserve to be
at
beaten
the
up
end
either.
of all of that, it still will not change the fact that the defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used.
And that's what state will focus on.
Danger need
That
not have been
defense.
actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real
Perception.
that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force,
reasonably cautious,
this is important.
a reasonably
A
cautious
reasonably cautious
and prudent person under the same circumstances would have believed
the
use of deadly force was necessary.
Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating
Same
with
thing.
each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly
Justifiably
crashes
use
like a
of
house
deadly
cards.
force. Justifiably.
But there's more.
But wait, there's more. That 3 crime scene tape with every suitcase.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next 2 paragraphs.
Have you still here? Is this what you're talking about when they say the post hoc ergo? I can't even read my own writing. Propter hoc. Is that what that's pertaining to? That particular reference there? If I understand that definition correctly.
Some of the most critical testimony
I'm not
in
sure.
this trial
I'm not sure. It wasn't actually televised.
is her testimony on the stand.
I don't think so.
It was a great day.
I think it was Jay.
We were doing puzzles and
And
artwork,
arts and
dancing with
crafts.
the dogs, listening to music. Tag, you're it. Hide and go seek time. George gets into the suitcase. She comes and
You
zips
can't
him up.
find me. Nah.
We're still laughing about it. We're still laughing after he's zipped up in the suitcase.
Oh, strawberries.
And then that's when
Forgot about that.
George had the temerity to ask, Jorge Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer. She was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own words, we were laughing and playing right before he wanted to be let out because he couldn't breathe.
Don't need to watch me do this. Shovel strawberries and yogurt in my gob.
Paragraph 1.
I'm still here.
The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger, other than using deadly force on Jorge Torres.
I can't believe this is all they've come up with
He couldn't exert
for their
anything,
closings.
ladies and gentlemen. He couldn't. Jorge
They
Torres
put zero
couldn't even
effort into
exert
this.
his arm
Zero.
out of the suitcase. How on earth could he have exerted a force so great to justify his Judge object?
Approach.
Mm-hmm. There's a difference between justifiable force when it's described in the jury instructions, when it's pertaining to deadly force, not justifiable force trying to get out of a suitcase. Different. Oh, it's just, yeah, exactly. They've just basically gone, this is an open and shut case. The video is all we need. That's it. And did nothing. Not until 4 days before the trial. And even that turned to shit. Mm. Did you have a look at, Elizabeth, that their rebuttal witness, their supposed expert? What was her name?
Objection overruled.
This
Resting bitch face.
no help to the defendant. Second paragraph. In good faith, Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force, but Jorge Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, Jorge Torres never got a chance to do anything. Jorge Torres never was able to mount any aggression towards the defendant.
How do you know?
Therefore, this paragraph
It's only a 2-minute
is inapplicable.
and 20-second video.
And the law tells us as well that physical contact in this case includes any restraint on Jorge Torres's movements. The law also tells us again to find that Sarah Boone, because of
How
prior
isn't she?
difficulties with Jorge Torres, had reasonable grounds to believe that
I couldn't help myself.
Great bodily harm, of
She
death,
did that all
great
day,
bodily
like
harm
6 hours.
at the hands of Jorge Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to Jorge Torres. But again, those grievances will not change the law, and they will not change the fact that justifiable use of deadly force fails as a defense for the defendant.
Or does it?
If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the the special instruction on battered spouse.
Yep.
You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony.
You know why they're reading this out? That's because they've not done one scintilla of research on actually what battered spouse syndrome actually is. Or PTSD, none of it.
Regards to battered spouse. Ladies and gentlemen, we've heard from three experts in the
Two.
areas of battered spouse in this case. I think at the outset, it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact that George Torres at points mistreated Sarah Boone,
Mistreated cerebellum.
did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did these awful bad things, that now through the rest of time,
I know where I want to hide
battered
that
spouse,
demonstrative aid.
and she just has the right to kill him, or to make him suffer, or to punish him, or to make him feel uncomfortable, or decide that he needs to be confined to a box. No. What the battered spouse syndrome instruction does is it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brannon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brannon's testimony that was very critical.
I'm about to
Dr.
start drinking
Brannon
myself.
talked about rule-outs. He talked about the fact that when emotions
There's that
and
one.
emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brannon, include alcohol abuse. Dr. Harper should have listened to Dr. Brannon's testimony because Dr. Brannon completely undercut Dr. Harper's testimony. Dr. Harper relied heavily on the words of the defendant.
That's because she spent 9 times, like she visited her and assessed her on 9 occasions. Oh, the same, like around the time of the incident when it was relevant. Not for 2.5 hours, 4 days before a trial. Like 2020, I don't think Sarah Boone even heard the term battered spouse syndrome. This didn't come up until James Owens, 45 days before the trial. So I'm sorry, but she did not fit the narrative to Dr. Harper, the assessment, the expert. She couldn't have.
Who was abusing alcohol
Yep.
at the time of these events.
Yep. To cope with what she was dealing
Then
with.
you heard
Yeah, she's
from the
got
expert
issues
from
for
the
sure.
state, Tanya Warner. In her opinion, was much more straightforward. Remember, Dr. Brannon did not render an opinion as to whether or not she suffered from battered spouse.
Yeah.
Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome.
Mm-hmm.
But she also applied what Dr. Brannon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on meant that the trigger was not domestic violence or some threat.
Really?
In the defendant's own words, the trigger was him wanting to get out.
No,
Being
that's not
reminded
what.
of the bad things that he had done to her. That's not imminence of fear.
Oh, really?
That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of
You just sucked the
this
wrong end of my
event,
vape.
it still does not save the day. Because all the battered spouse trigger law
Judge's
tells
vote.
us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat is imminent.
Correct.
And we know from the evidence, we know from the videos, there was absolutely no threat.
So you're telling me that if you, say, got robbed at knife point, yeah, and you developed PTSD from that, could have only happened once. Hopefully it never happens, but next time you're talking to someone in the kitchen and they're waving a knife around while they're talking, that's not going to trigger you? Maybe? No.
And we know there was no threat because Jorge Torres never got
Absolutely.
out of that box. He was never got out of that box until
Enough
sometime
with the box.
on the early afternoon of February 24th.
What year? Dumbass.
Mr. J, can you please publish from stage 21?
Mr. J, please publish. Look at that frown. I'm so serious. I'm wearing my Thailand three-piece suit. It's ill-fitting. And I'm ever so serious. Elizabeth, check your emails. Yep. And this happened for years, 3.5 years. Yeah.
I'm going to go to court and I'm going to tell the judge.
Now, this is the video that I think is part of the honeymoon phase. Okay? He's trying to make up for what he's done, and she's instructing him on what to say to make her feel better, to justify stuff. Does that make like? It's hard to explain, but yeah, this is the honeymoon phase, in my opinion.
Listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Her being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismiss,
dismiss this case,
closed,
drop it. She is not the type of person.
good person,
She's a great person.
angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet,
What?
and it could.
Because I love you. Whatever you want me to say. God will prevail and He will take us out of this situation. Love you.
Clearly, Jorge Torres is dominating the defendant. Clearly, Jorge Torres is the one telling the defendant what to do. Clearly, Jorge Torres is the one calling the shots at 4748 France Lane. Ladies and gentlemen, are we so sure that Jorge Torres wasn't the person suffering from battered spouse syndrome?
No, I think he was, for sure.
Next, we're going to come to the justifiable use of non-deadly force. the language and the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. George Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case, the awful threat, was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you publish from States 17, IMG 1063. It was a short video. Well, what's one of the things that we notice by this point? You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later, from the time that started, we see that the makeshift coffin that he's in has been moved. And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres in this box, slowly being killed. Next, we come to weighing the evidence. This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider. Did the witness have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court.
Not the StreamYard link, the picture. There's a picture one I sent you just before the StreamYard link. Click on the picture and open it up.
Jorge Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And the litany of her intoxication in versions of events is evidence of that. Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not Jorge Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listen to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Kopsel and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated.
You think?
Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me. Oh yeah, I was in fear for my life. When she said at every turn, no, It was just a great day. We were having fun. Oh my God, I can't believe this. We were doing good. The only stress we had was about jobs. And now, 4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder. I ask you, ladies and gentlemen, do you have any doubt about the defendant's guilt when she described using that baseball bat to hit Jorge Torres's fingers back in the suitcase when he attempted to save his life? Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of Jorge Torres being murdered and her laughing about it and talking about the fact that he cheated on her? Do you have any doubt after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated Jorge Torres? And if you say, Mr. Cacciatore, I still have a doubt, well, then the law asks you, is that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder. Thank you.
Members of the jury, it is 4:04. As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. Do not have any discussions among yourselves or anyone else.